welcome back, everybody. We have several tragic cases making headlines, all with one common theme: innocent shooting victims being at the wrong place at the wrong time. 65-year-old Kevin Monahan is charged with second-degree murder after shooting and killing 20-year-old Kaylin Gillis on Saturday. Officials in upstate New York say that Gillis and three friends were looking for another friend's home when they turned around in Monahan's driveway. Monahan fired 2 shots at the car, hitting Gillis. The sheriff says no one had gotten out of the car at the Monahan home, and they appeared to be turning around to leave. Because the area is so rural, this group apparently had to drive several miles before they had enough cell phone service to actually call 911. When deputies got to Monahan's home, they say he was uncooperative. Monahan currently sits in the Warren County Jail without bond. A similar incident occurred just 3 days later in Elgin, Texas. Shortly after midnight on Tuesday, 4 cheerleaders went to a supermarket parking lot. They used the lot for carpooling purposes after practice, and police say that Peyton Washington and Heather Roth were shot after Roth entered the wrong vehicle, mistaking it for one of their own. Authorities say that the man in that car got out and opened fire. He has been identified as 25-year-old Pedro Tello Rodriguez Jr. He has since been arrested and charged with deadly conduct, a charge that carries a sentence of up to 10 years in prison. The investigation is still ongoing, and officials say that more charges could be added at a later date. Roth suffered minor injuries and was treated and released at the scene. According to a GoFundMe page for Washington, she remains in stable condition in the ICU after suffering organ damage and other serious injuries. The page has raised over $100,000 as of Thursday afternoon for medical expenses. Now, unfortunately, it does not stop there. That same Tuesday, a 6-year-old girl and her parents were shot in North Carolina after a basketball rolled onto a neighbor's lawn. A group of children were playing outside in the neighborhood just before 8 p.m. when the ball rolled into the yard of 24-year-old Lewis Singletary. When 6-year-old Kinsley White went to go retrieve it from his property, police say the suspect started shooting, striking the young girl and her parents. White and her mother were treated for minor injuries and released from the hospital, but the young girl's father, who was reportedly shot multiple times, is still hospitalized with serious injuries. Authorities say the 24-year-old suspect is still at large and is considered armed and dangerous. He's already facing several charges, including attempted first-degree murder. Brian, the 2 shootings that involved cars, if they go to trial, how would they differ or how would they be the same?
I think they're going to be the same in the sense of they're in cars and they're getting shot at. I don't see a potential defense for the two Texas cheerleaders who were shot, because while they did enter the vehicle, they did leave, and then the person who shot then got out and shot them. So what's the defense there? Like, what are you arguing? That just seems like blatant, serious assault with a weapon. And in the sense of Gillis on the turning into the wrong driveway and then backing out, we hear later on that he supposedly told neighbors that he was irritated by people being in his driveway and he was looking forward to doing exactly this. I think those text messages may negate any, if there was ever a possibility of self-defense, which I don't see, argument there. So I think they'll be similar in the cars, but difference in defenses.
Oh, I agree with you. That doesn't really work. Terry, let's talk about Robert Singletary. So he chased a family down the street and shot at them for retrieving a basketball from the yard. How can he claim self-defense?
Well, he's going to try, but it's not going to work. And this is probably, of the cases we're discussing, the worst. It involves a 6-year-old girl, and all 3 were shot. Fortunately, they all survived. But here, he is going to try to claim that. And in North Carolina, you do have stand your ground, which means that you can use force you think is going to reasonably protect you from deadly force or from getting serious bodily injury. And he can't claim that. None of that was happening here. They were looking for a basketball. There's also castle doctrine in North Carolina, and it just means you can do the same thing if you're in your home. I don't think he's going to be able to claim that here. He was looking for them. He was going down the street. He was shooting wildly. It's not going to work.
Yeah, I think those are all really bad cases for the shooters and just terrible situations all around across the country. When we come back, rapper Tory Lanez faces over 20 years in prison for shooting music artist Megan Thee Stallion in Los Angeles. Will his defense team secure their client a new trial? We're breaking down the arguments up next. And welcome back, everybody. We finished today's show out in Los Angeles, where sentencing for rapper Tory Lanez has been delayed as he fights for a new trial. Lanes was convicted of felony firearms charges back in December for the 2020 shooting of rapper Megan Thee Stallion while leaving a pool party. Lanes faces a maximum sentence of over 22 years in prison. That sentencing hearing was initially scheduled for January, but it's been delayed several times as Lanes acquired new attorneys for his case. Those attorneys, Jose Baez and Matthew Barhoma, who's appeared here on the Law&Crime Network, filed a motion for a new trial back in March. They claim that certain evidence and witness testimony was prejudicial and that their client's right to choose his own counsel was violated. The prosecution filed a motion in opposition to the defense's arguments, saying their claims lack substance. In a hearing on Monday, Lane's defense said that they will file a supplemental response to the motion on May 1st. The judge set a hearing for May 8th to discuss the motion. Now, if a new trial is denied, the judge expects Lanes to be sentenced within 30 days of the hearing. It's time to bring back in my co-hosts who've had a chance to read the court documents in full from each side. Brian, I'll start with you. Can you give us some specifics on why Lane's defense team wants a new trial, and is it reasonable?
Absolutely, and excuse me looking down because it is an 84-page motion, so I had to get specifics in here. There's a number of things. So the IG post, the character evidence, they're saying it went to the theory of the prosecution's case. They shouldn't have had it. Where this post, who they don't really know who is the author of it, says that Tory Lanez is lying about shooting at Megan Thee Stallion's feet. Inadmissible DNA evidence, inculpatory statements, meaning incriminating statements, where he, being Lanes, was supposedly saying, please don't say anything, I'm on probation. He wasn't at the time, so they're saying that shouldn't have come in. Right to counsel, evidence of the defense's creative expression, meaning his tattoo, his lyrics, the music video, as well as a confrontation clause when it came to Harris. These about 5 or 6 different arguments are what they're saying amounted to impermissible evidence coming in, and this is why they should get a new case. They're going to have the hearing, as you said, on May 8th. The judge said it should be about a 3-day hearing to see if these elements rise above that level of saying you need a new hearing, rather than just saying this is harmless error. You're already convicted. All
right, so that's the defense's side. It's a shame Brian doesn't have a photographic memory and couldn't remember that off the top of his head. But Terry, I go to the prosecution. They don't believe that Lane's entitled to a new trial. You agree? If so, why?
I do agree with the prosecution. They are not entitled to a new trial. As you know, if the evidence was wrongly admitted or wrongly denied, then in fact you get a new trial. Brian mentioned the fact that the Instagram was admitted, and the reason that they're arguing is it wasn't a proper foundation. It was a proper foundation. He's talking about the DNA evidence that was admitted. They're saying it shouldn't have been admitted. It was admitted because it was no objection from the defense. So there's no reason not to admit that. The judge was right on that as well. And I do think the confrontation, he had a right to confront Harris. So I think it was all correct.
Both sides. We'll see what happens. Brian, Terry, thank you. Everyone out there, thank you. We're going to see you next time as we discuss justice in America.